All right, are you ready?
Yes, sir.
Let's roll.
All right, Louise.
Sean, you ready? Hi, good morning. Thanks for coming.
Good morning, Judge. Bottom of one.
Okay.
Top of two.
Chavez, Mr. Chavez, you were charged with reckless driving and unlawful carrying of a weapon. On the weapon case, you're facing up to a year in jail and or a $4,000 fine. And on your reckless driving, up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On May 7th in Harris County, officer on patrol observed a motor vehicle with two males standing up through the sunroof while traveling on the roadway. Also traveling with lower high beams while approaching traffic. Traffic stop was conducted on the vehicle. The witness and second witness advised that they were standing through the sunroof. Defendant did not have a driver's license and showed officer a Honduras birth certificate. MDT search showed the defendant to have 4 active traffic warrants. And upon exiting the vehicle, officer observed a pistol on the floor behind the driver's seat within arm's reach of the defendant, who did not have a license to carry. The 2 witnesses advised it belonged to the defendant.
Got it. Okay. And so the reckless driving was the fact that he's driving and then they're through the sunroof.
Yes, Judge.
Or both of them or just one? Okay, do we have any co-defendants?
No, Judge.
Mr. Chavez Medrano, you do not have a Texas driver's license. You are not allowed to drive. I want you to understand that I take this extremely serious. You are not in traffic court anymore. This is big boy court. You go to jail, you may be there for a long time. If you are not in this country with permission and you go to jail and immigration finds you, they will very well put a detainer on you. You'll be there for a good 6 months and then you get shipped off to immigration where you sit for another 6 to 9 months. Do you understand? Do not drive. This is a promise, an affidavit that you're going to swear to me today that you're not going to drive. I don't care what you have to do in this life. I don't care what kind of car you have. I don't care where you have to go. Do not drive. Also, as a condition of your bond, you are not to be in possession of any weapons. If I find that you have a weapon, then likewise into jail you go. If I have to revoke your bonds, you will not get any more PR bonds, and I'm going to make your bonds high. Do you understand?
Yes, sir.
How old are you, sir?
21.
How do you support yourself?
I work in construction.
Who do you live with?
With my father.
Okay, we are going to reset your case to give you time to hire a lawyer. I'm going to have you come up here, swear to us that you're not going to do 2 things. First, you are not going to drive. Next, you are not going to be in possession of any weapons. Mr. Chavez, a lot in this life depends on who you hang out with. If you hang out with the wrong crowd, or maybe you are that wrong crowd. If you do, it's not going to go well between us. Come on up, we'll have you sign this. I'm going to have you take your seat in the jury box while we get the rest of your bond conditions. Yeah, please, on both cases. We'll file it on both so that in the event that we revoke both cases.
All right, Judge. Bottom of 3, top of 4. Damien, come on up.
Hi, good morning, sir. How are you, man?
Pretty good. Yeah, Jackie.
Damien, come up. Good morning, sir. Sir, you're charged with driving while intoxicated and unlawful carrying of a weapon. On the gun case, you're facing up to a year and or a $4,000 fine. On the DWI, up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On May 10th in Harris County, officer dispatched to a medical emergency call. Upon arrival, officer observed a motor vehicle with ignition on and found it to be in drive, keys in the engine and still running. The defendant, the driver, had an odor of alcoholic beverage and glossy eyes and admitted to consuming 2 Miller Lights. SFSTs were conducted, 6 out of 6 HGN, 2 out of 8 walk and turn, and 3 out of 4 one-leg stand. DIC was read and the defendant consented to a blood sample. Inventory search of the motor vehicle found a Glock 19 in the vehicle and a backpack.
All you said was that he's in the car, keys in the ignition. Is he in the roadway? Is he flying? Is he driving? Is he
Yes, Judge.
parked?
So it's the 8700 block of Fry Road, a roadway in Cypress.
Okay.
Observed a motor vehicle with the ignition on and in drive, keys in the engine, brake lights on, and still running. Defendant seated in the driver's seat.
Where is he exactly? Is he in the middle of the roadway? Is he in a
The didn't
driveway?
say what part of the, like where in the road. It just says the 8700 block of Fry Road, which is a road outside.
I mean, are we just to assume things now, you know?
Well, I would say, Your Honor, that finding a vehicle in the block, 8700 block of a road, to a medical emergency dispatch, and then seeing a defendant in the driver's seat. I don't know what we're assuming at the next step. We have him with a engine on, vehicle running in a roadway.
Well, typically an officer will say, okay, he's in the middle of the roadway, he's asleep in the middle of the street, you know, and he's by himself. So how else would he, you know? But here we just have, he's in a car with ignition in the 8700 block. I don't know what the hell the 8700 block is.
I understand, Judge. That's what we have in the DIM, so I have the offense.
I'm going to find no probable cause to go forward with your case. On both cases, they may very well indict this case. You got to be on the lookout because they may, you know, file this case against you at another time. Be very careful. Really, we're not asking much. We want our streets safe. Every day someone dies from a DWI in our county, and it's so not fair. Do you understand, Mr. Damien? Take a seat. Okay.
Thank you. Your Honor.
All right. Take care.
Have a good weekend.
You too. Ready? Hi. Give me a second, Mr. Bart. Hi.
Hi, Your Honor, I'm approaching about Alejandro Gonzalez.
Correct. Yes.
Signed on to it.
Thank
I don't
you.
know if there's anything else that you want us to do.
I don't know. I mean, we really just. Yeah, I know. So I don't know how much, is it 45? Is it 90? What is it the day that it's? I don't remember the day. I know because it's been a minute. So just be
Yeah.
wary that I don't know when the timing is of when it's due.
So,
Just, I don't know. Don't worry about it.
Yeah.
Just be careful because it might be pretty close to
Okay.
when it needs to be filed. I don't know.
we'll get it taken care of.
Yeah, I trust you. Just at this point, I don't know. I mean, just, you know, let me know.
Okay,
Really. Yeah.
all right. Well,
Okay.
we've signed on to it.
Okay.
Have you signed the order and everything?
Yep, I'll do it right now. And then I guess if you need anything else, I've already found him indigent.
Okay,
I've gotten you granted the record. Ramona's working on it now. I don't know how far she's into it. It wasn't a long trial. It was pretty short. Was it one day? I mean, it amounted to really, remember?
Yeah, it was board out one day and then the trial lasted for one day, so.
Yeah, so it was pretty short. So, yeah. Yeah.
All right.
Okay, just let me know if you
Thank
need
for
anything.
reaching out.
Yeah, of course. Thank you, Mr.
Have a good one.
Right, we stay for the next one?
Yeah, let's do it.
Bottom of 19, sign. Someone up?
I'm thinking that 40,
No, thanks.
46 right away.
46. What the hell's wrong with you, man? 46, 46, 42. Jeez. My God, like kicking the ding ding. All right, Ms. Sands, you were charged with
One thing.
SAE.
Yes, ma'am. Thank you.
Tell me when you're ready.
Oh,
I have under Reyes, but one of the crime.
Or 2619013.
Yes, sir. Got it.
Got it. Okay. Ma'am, you are charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On May 8th in Harris County, officer observed a vehicle going 40 mile an hour in a 45 mile an hour zone, failing to maintain a single lane, almost causing an accident with another vehicle on I-10. Traffic stop was conducted and the defendant was identified as the driver and sole occupant. Officer observed odor of alcohol and glossy bloodshot eyes. Defendant stated she drank a margarita and was driving home from a bar. SFSTs were conducted, 2 out of 6 HGN, 5 out of 8 walking turn, 2 out of 4 one-leg stand. DIC was read, and defendant provided a breath sample, but was unable to complete the breath sample, so then provided a blood sample.
Does she have a license to drive?
She does, Judge.
Yes, I do.
It's eligible.
Ms. Sands, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be tested. Because it's a second offense, I'm now ordering you not to drive any vehicle that's not equipped with an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail. I send notice to DPS in Austin so that if a police officer stops you, they will know of your interlock requirement and they will take you to jail if your car doesn't have one. You understand?
Yes, sir.
Do you have the ability to hire a lawyer?
May I ask for a court appointment?
Well, you have to qualify. What do you do for a living, ma'am?
I have 2 jobs.
And how much money do you make a month?
About 2,000 between both.
And who do you support, if anyone?
My father.
I can give you an application. I'll take a look to see whether you qualify. I need to know everything about you. It's based on household income, not only your income, but your father's income, social security, any other, anything that you have coming in from all sources. Deputy Williams will give you an application. I'm going to have you go to Victoria Center Reset. You'll eventually get with Veronica for your bond conditions, and then we'll have you take a seat in the jury box while you fill out the application. Please.
All right, Judge, top of 1, Abergun.
Mr. Abergun, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 18th, 2025, complaining witness in Harris County advised that while she was sleeping, the defendant, her ex-boyfriend, woke her up screaming at her and threw her cell phone at her. The complaining witness advised the defendant then threw items from around the bedroom and threw her on the bed, punched her in the stomach, and pushed her down when she tried to get up, then grabbing her neck with both hands and threw her against the bed, choking her for about 10 seconds. Complaining witness stated she could not breathe while the defendant was choking her. Complainant's mother came in, which caused the defendant to let her go.
Really? And we're here in misdemeanor court? Does he have anything open right now? Can you run an NCIC, please?
Yes, sir.
Mr. Abergun, as a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to test you like crazy to make sure that you're not using. I will test you within the next couple days. Expect a lot of tests. If I find that you're using, I will revoke your bond and put you in jail. I will protect my community at all costs. Your bond is $7,500 now. If I revoke your bond, it will double, triple, maybe quintuple. Do you understand? You are not to have any contact with the complaining witness in this case, not to be in possession of any weapons as well.
There's nothing open now, Judge.
I see that he had a couple out of county cases that were recently disposed of. What all did he have open?
There was a Fort Bend evading the motor vehicle, but it was already taken care of. It's not open anymore. I don't know what the disposition on it was.
Is that the only thing you see?
Yes, Judge.
How do you support yourself, sir?
I had a jump on, but I just got in a car accident. They let me go. That's how I got it.
Okay, Deputy do you mind giving an application? I'm going to give you an application for an appointed lawyer. I need you to fill it out. I need to know everything about you. You will be expected to work. You don't get to sit here, have a court-appointed lawyer while everybody pays for you and get to sit on your tuchus doing nothing. I'm going to bring you back in 2 weeks and I want to see what you have done to get a job. Do you understand? All right.
All right, Judge, bottom of 6, Escobar. And inside here, 6.
Mr. Escobar, you're charged with unlawful carrying of a weapon. You speak English, sir? You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On May 8th in Harris County, officer conducted a traffic stop on a motor vehicle with completely tinted front windows covering the expiration tag. When speaking with the defendant, the driver, the officer observed a heavy odor of marijuana from the motor vehicle. A probable cause search located a firearm in the upper dash console and a small bag of marijuana in the bottom console.
Does Mr. Escobar have a license to drive?
He does. Let me double check.
Mr. Escobar, I'm going to find that there's sufficient probable cause to go forward with your case. While this case is open, you were not to be in possession of any weapons. You are not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance in your name. If you do not have car insurance, then do not drive. That is also a condition. You understand? You violate this, I will revoke your bond, put you in jail. No more PR bonds for you, sir.
He does not, Judge.
You are not allowed to drive. You do not have a Texas driver license. Do not drive. Do you understand? I don't give a rat's behind what you have to do in this life. Nothing matters and there's no justification. How do you support yourself? How do you support yourself? What do you do for a living? We will give you time to hire a lawyer. I'm going to have you come up here, sign this where you promise us you're not going to drive. I will get you to Victoria Sign and Reset. I'm going to have you take a seat while we get your bond conditions. After that, we'll let you go. When you come back, please have a lawyer. All right.
All right, Judge, top of 7,
No weapons.
Yes, sir.
And no drug.
Yes, Judge.
Andre Luis.
You are Mr. Etienne. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Officer, sorry. On March 10th, 2022, in Harris County, Texas, officers spoke with a reporter who stated that a witness, the sister-in-law, called her stating she needed to come over. Reportee arrived and observed the complaining witness lying on the closet floor with multiple injuries. Witness was intoxicated and stated that she and the complaining witness, her husband, were in a verbal argument about cheating. Complaining witness got loud and aggressive, so she called the defendant, the witness's son, to come over. Witness then did not want to continue speaking. Complainant was being checked out by medical and stated that they were having an argument, and the witness called the defendant to come over. Complaining witness stated the defendant then hit the complainant multiple times, causing his eye to swell shut and bleed from his lip. And then the defendant drugged the complaining witness into the closet. The complainant stated he felt pain and discomfort and that the defendant left the location. Complainant was transported by EMS to Ben Taub. Witness gave officers defendant's name and date of birth, and complaining witness identified the defendant as the person who assaulted him.
All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person and not to be in possession of any weapons. Do we know whether there's alcohol with him?
Not from the DIMS, Judge. No indication of alcohol.
Okay. A order for protection has been entered in this case, and you need to get to know it. If you violate this protective order, like going to the place listed in the protective order, they can file additional cases against you, and a violation of protective order is one of the worst misdemeanor cases you can pick up. You understand? We are going to reset your case to give you time to hire a lawyer, so we'll have you go sign a reset. We'll have you take a seat in the jury box. We get your bond conditions. Once you sign them, you'll be free to go. Please. No contact, no weapons.
Yes, Judge.
Counsel approaching on Ochoa, page 15.
Good morning.
How are you, Judge?
Hi, Marcus. Happy Friday, man.
Happy Friday.
What's the last name?
Ochoa?
Ochoa.
OCHO.
Good morning, Mr. Ochoa. Sir, you were charged with driving while intoxicated. You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On May 10th in Harris County, officer observed a motor vehicle that had only its parking lights and had corrected the vehicle and got back into its correct lane of travel. Officer attempted to conduct a traffic stop, but the driver did not stop immediately and continued to leave his lane of travel, weaving inside his lane, hitting the fog line on the right side of the lane. Driver eventually stopped. The driver was identified as the defendant. Officer detected a strong odor of alcoholic beverage, bloodshot, glossy eyes. Defendant admitted to consuming six beers. SFSTs were conducted, 6 out of 6 HGN, 3 out of 8 walk and turn, and 2 out of 4 one leg stand. DIC was read. Defendant could not or would not perform the test correctly and provided a blood sample.
What do you mean? What tests he was not doing?
The breath test.
All right, got it. Okay. Mr. Ochoa, I will find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be tested. If I find that you're consuming, I will revoke your bond and put you in jail. Does he have a license to drive?
He does not, Judge.
Okay. Does he have any prerogative behind? Can you run him? Mr. Ochoa, you do not have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today, promising me you're not going to drive. I really don't care what you have to do in this life. If you do not have a Texas driver license and insurance, do not drive. I'm not going to warn you again. Do you understand?
Yes, no prior, Judge.
Okay. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Marcos. If he tells me he cannot get a hold of you because you're not responding to him, I will revoke your bond. I don't know what your immigration status is. If you are not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you and you will sit in custody for a long time. For now, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and after that, you're free to go. Thanks, Marcos. Yeah, have him come up here real quick and then.
All right, Judge, top of 8, Gonzalez, come on up.
Judge, the conditions for allergen, is that state conditions, no contact while open?
I think so, yeah. There's no contact, no weapons. No. You with you.
Okay.
Yeah, no, yeah. I wouldn't know drugs, no alcohol, and frequent testing. Yeah.
Okay, just wanted to double check.
All right. You said Gonzalez, right?
Yes, Judge, top of 8.
Right. Okay. You are Mr. Gonzalez. Sir, you're charged with reckless driving. You are facing up to 30 days in jail and or a $200 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On May 8th, in Harris County, officer observed a group of motor vehicles meeting up at a closed warehouse parking lot for what is known as a street meetup. Officer in plainclothes observed the motor vehicle do donuts in a pit around 65 to 70 people, getting within striking distance of 5 to 10 feet of others. Motor vehicle then left the location and a traffic stop was conducted. The defendant was identified by his Texas driver's license. Officer also observed a 5-year-old in the back seat. The defendant admitted that it was his daughter.
Does he have a license to drive?
He does, Judge. Checking eligibility.
Mr. Gonzalez, I'm going to find that there's probable cause to go forward with your case. If I find that you drive like this again, I will revoke your bond and put you in jail. You understand, you will not get any more PR bonds. Not only that, the DA's office has now started to seize and take cars from individuals who participate in these types of actions. So you pick up another case, you may very well lose that car. Do you understand?
He did not have an eligible license, Judge.
You are not allowed to drive. Do not drive. I'm warning you now. If I find that you do, and I don't give a rat's behind what your excuse is, it's really not going to go well between us. You understand? How do you support yourself, sir?
I work.
What do you do for a living?
I just got a job at, I'll take you parts.
Great. What kind of money are you making a month?
$50 hours.
Are you working full time?
Chavez?
Do you want to apply for an appointed lawyer or do you want to try to go hire a lawyer? Okay, we're going to give you time. I'm going to have you sign a reset. I'm going to have you take your seat in the jury box while we get your bond conditions. You're going to sign this affidavit promising us you're not going to drive. Do not drive. I don't care what you have to do in this life. Do you understand? If I find that you drive in violation of this affidavit, I'm going to make your bond so high, you'll have hair falling out. Do you understand?
Yes, sir.
Come on,
State conditions, Judge.
please. Yeah. Just no driving.
Already filed.
I guess just no driving.
All right. All right, Judge, Taco 10. Docket, 8:15.
Mr. Burns.
We're good.
Wow, another one of these. Second time and
Yeah, this is my third one.
Really?
Right, yes, sir.
oh, you're cornering the market.
Yeah, exactly. I'm getting ranked as the smoke shop.
Unintended.
Yeah.
All right,
You know, these cases, it's frustrating because the law changes so much on these are like the farm bill. And are they going to do it? Is it how to sign it? And they don't change the law, but they change the way they enforce it. And instead of local PD coming and saying, hey, can't sell those, can't sell this, we'll be back in 2 weeks, we don't want to see any of that. They just come and they arrest them. It's a lot to keep up.
interesting. Let's go through it because it's interesting. You're charged with selling a prohibited e-cigarette using an advertisement. Let me make sure that that's correct.
Look at it. Is this advertising targeting children or not?
Prohibited e-cigarette products. Do you speak English, sir? Yeah. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On February 23rd, 2026 in Harris County, officers from Kingwood Crime Suppression Team conducted an e-cigarette retailer inspection. Upon arrival, the officers observed the smoke shop to be open and the defendant to be the clerk and employee who gave consent to inspect the store. During the inspection, officer observed numerous e-cigarettes, juices, and batteries whose boxes advertised that they were made in China. Foreign adversary designated by 15 CFR 791.4, whose boxes clearly stated made in China in violation of Texas Health and Safety Code 161.0876 B1 through 4.
This is, I looked this up.
Yes, and so my understanding of the law, if you looked at it, you tell me if you have the same thing, is that it's the liquid cannot be made in China, not the battery, not the device, is that it cannot be filled with a liquid.
No. The fact that it's
It just has made it.
made in China. I think that's, I mean, I pulled the Code of Federal Regulation last time. When I got this case initially and I got the 2B, I looked it up and hold on, let's look it up. Let me see.
Well, then maybe that was the worst thing to say.
No, look, let's look it up because I'm probably wrong. I'm wrong all the time. Let's see. So 15 CFR 791.4.
I mean, it's only devices, the electronic component is manufactured in China, but then it's filled here in the States with liquid made in the States.
It says here, the secretary has determined that the following foreign governments or foreign non-government persons have engaged in long-term pattern or serious instances of conduct significantly adverse to the national security of the United States or security and safety of the United States persons, and therefore constitute foreign adversaries solely for the purposes of the executive order, this rule, and any subsequent rule. The People's Republic of China, including Hong Kong Special Administrative Region and Macau Special Administrative Region, quote unquote, China, and then Cuba, Iran, North Korea, Russia.
That's the
Maduro.
designation, but what about the?
Yeah, there's another, the health and safety code. Let's go there next.
Thank you.
So we know, but what gets me is, okay, what about Costco? What about all the stuff that's in Costco, right? So let's narrow it down.
Where does this foreign adversary
Texas Health
designation?
Safety Code. So 161.087 B 1 3
And B37.
So it says it's distribution of cigarettes, e-cigarettes, or tobacco products. Current as of January 1st, 2024, except as provided by subsection C, a person, including a permit holder, may not accept, redeem, offer to accept or redeem, or hire a person to accept or redeem a coupon or other item that the receipt may use or receive a free cigarette, e-cigarette, tobacco product, or sample cigarette, e-cigarette product. B1. Where's 3-4?
So Judge, I did some, when you look on other websites like Find Law and stuff, they don't have the fully updated version, the statutes.capital.texas.gov as B3 and 4, which is the section that says that is wholly or partially manufactured in or marketed as being manufactured in China or, and then the country.
What do you reference? What do you reference?
I believe it's that.
Were you looking at that same one?
I'm being schooled by industry guys here at the same time.
Show me, can I see that? Because
Yeah, absolutely.
The intent was the liquid.
Yes.
Of course, all these devices are made in China.
you know what that's. Let me see.
Yeah, and then you scroll down, it's the, so you charge it wholly or partially manufactured in China.
I don't think there's any, I don't believe there's any concern of like spying and adversarial stuff in a tobacco device, right? I believe it's the intent of this whole thing is the liquid and the health effects of the liquid being manufactured in China versus made in America. The health and safety code, right? It's not an espionage code.
Right. B134.
And so, of course, the device is made in China, like China and Taiwan. And where else could you get? Do you think there's any of these things that are made in America that's made?
That is wholly or partially manufactured in or marketed as being manufactured.
What is that? That's what I'm.
Yes.
A person commits an offense if the person markets, advertises, sells, offers for sale, or causes to be sold an e-cigarette product that is wholly or partially manufactured in or marketed as being manufactured in China.
It's broad. I believe the legislative intent was for the liquid, but it's the way it's written, I understand it's broad.
All right. I'm going to find probable cause, but I'm not going to put any conditions. Just be careful.
Absolutely.
So I will find probable cause, but just be careful. You know now that it's.
You see, if we're struggling to get caught up to speed here, as two lawyers and a judge, I mean, just a small business owner is crazy.
I get it.
And so it just, first of all, it should be enforced civilly, but the law was written as a written simply. Why not come in and just say, hey, all computer, those are in violation of coming back on.
Look it up. Look it up. Perhaps there's a law that says, I don't know,
Yeah,
do a deeper dive.
give them a heads up.
Yeah, I mean, normal course.
Right.
It would-
Should be reasonableness in it.
Like I said, I'm not going to put any conditions. Just be careful. Do not pick up any new cases, really. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court. Just stay in touch with Mr. Burns and he'll tell you if and when.
Zero issues.
Yeah, you're good. Don't worry. All right, thanks.
Right this way. All right, Judge, council's approaching for top of 23. Villarreal, someone up?
I couldn't find that. Couldn't find.
I know, so I struggled with it and I talked to Pam for that, and then I was able to find the statute itself on that government website instead. It's different.
All right, good morning, Mr. Villarreal. Sir, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Good morning, Mr. Newley.
Good morning, Your Honor. How are you today?
Pretty good,
On
thanks.
May 9th in Harris County, officers dispatched in reference to complainant said that she woke up and found a bullet hole on the door hinge to her bedroom bathroom, along with a hole in the north wall of the bathroom. Complaining witness picked up a bullet jacketing from the floor and hinge. Complaining witness believes the discharge came from her neighbor due to the trajectory of the bullet hole. Officer observed a bullet hole on the north side of the complainant's residence and a hole in the south side window of the defendant's residence. Officer made contact with the defendant, the neighbor, who stated that he had recently purchased the rifle, did not know how to properly use it. Defendant stated that he was performing maintenance on the rifle when he accidentally pulled the trigger, which discharged around into the south side of his room. He stated he tried to check on his neighbor, but could not contact her until she answered a call via Facebook Messenger, and the defendant admitted to the didn't say guilt, Judge.
Okay. Mr. Villarreal, I'm going to find that there's probable cause to go forward with your case. Have you been watching the news? A couple days ago, the same thing happened and an older lady in the kitchen died as a result. And now dude is charged with what? Manslaughter upstairs? No weapons. Do you understand? If I find that you have a weapon, I'm going to put you in jail and I'm going to make your bond high. Do not have any weapons, possession, care, custody, or control. Do you understand? Do you, yes or no? All right, we're going to have you sign a reset. I'm going to have you take a seat in the jury box so we get your bond conditions. Once you sign them, at that point, you'll be free to go. Thank you, Ms. Newell.
All right, Judge, bottom of 11, Hernandez, come on up.
I'm sorry, you said.
Hernandez on 11.
Good morning, Mr. Hernandez.
Morning, Your Honor.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 9th in Harris County, around 8 in the morning, officer conducted a traffic stop on a motor vehicle going 93 in a 65-mile-an-hour zone. The defendant, the driver, had bloodshot, glossy eyes, slurred speech, and a strong odor of alcoholic beverage from his breath. The defendant advised he had 2 beers about 2 hours ago, and the defendant was observed to be unsteady on his feet. SFSTs were conducted, 6 out of 6 HGN, 4 out of 8 walk and turn, and 2 out of 4 one leg stand. DIC was read, refused. Blood search warrant was executed. Blood was drawn. His license is available.
And any prior DWIs?
No, Judge.
All right. Sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
All right. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign and reset. You'll get with Veronica for your bond conditions, and then we'll see you in a month.
I do have authority.
Are they who?
Shelby Burns.
Dan, just let.
He didn't sign off.
We don't have him right now, so he is not attached to your case. So we're going to reset your case to give you time. You need to maybe talk to him more so he can come back and file an attorney of record. But at this time, he hasn't claimed to represent you.
Okay.
So we will give you time, though. So if you want to head on over, we'll have you sign a reset, and then we'll have you get with Veronica for your bond conditions.
All right, Judge, top of 13, Lee.
Good morning, Mr. Lee. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 8th in Harris County, officer conducted a consensual encounter at 7401 Colon Boulevard. Officer observed multiple no trespassing signs posted on a business property. Officer observed the defendant to be standing outside the location, leaning on a vehicle. Officer found the defendant had been trespassed from the location on May 5th, 3 days prior. The complaining witness, the manager at the location, stated that he told the defendant multiple times that he was trespassed from the location.
What was it? Was it a convenience store?
Let me double check it, Judge. That's what it sounded like. Yes.
Mr. Lee, I'm going to find that there's probable cause to go forward with your case. Just don't go back. That's the only thing I'm going to tell you, ask you to do. Just don't go back. Do you understand? Also, well, don't pick up any new criminal cases, but really, if you don't go back, all will be well. Do you have the ability to hire a lawyer? We will give you time. I'm going to have you go to Victoria Sign and Reset. I'll have you take a seat while we get your bond conditions ready. Once you sign, at that point, you'll be free to go. All right?
Bottom of state city, Otano.
Mr. Otano, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 8th in Harris County, officers conducting surveillance on a group of vehicles in a parking lot takeover. Officer observed the vehicle do donuts in a pit of around 40 to 50 people, getting within 5 to 10 feet of striking other people in the pit. Traffic stop was conducted on the motor vehicle when it left. Defendant was identified as the driver.
So he's doing donuts.
Yes, Judge.
Is he licensed to drive?
He does, Judge. I'm checking his eligibility.
Go. Sorry,
He had a license. I'm checking if it's eligible.
please.
As of right now, it is.
How old are you, Mr. Otano? You're 17. If I find that you drive like this again, I will put you in jail. I will deem you a public danger, and I'm going to make your bond extremely high. Do you understand me? You are not allowed to drive like this in any manner whatsoever. No reckless driving, donuts, street takeovers, racing. If you do, I will put you in jail, and then I will take your ability to drive away from you. They have been seizing and taking cars from people who participate in these types of actions. So if it happens again, you may very well lose whatever car that you're driving. You understand? What are you doing with yourself these days? Okay. Do you want to apply for a court-appointed lawyer, sir? Okay. Deputy Williams will give you an application. I'm going to have you sign a reset, then we will have you take a seat in the jury box. You will sign bond conditions. One more thing. You are not allowed to drive unless you have car insurance in your name. If you do not have it, then do not drive, and that is a condition of your bond as well. You understand? All right.
All right, good. Next is age 16, Perez. Come on up.
So no reckless driving, donut street takeovers.
Yes,
You must drive with insurance. You said 17, right? Is that what you said?
Bottom.
Mr. Perez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officer observed a motor vehicle on I-45 appeared to be speeding above the posted speed limit of 65 miles an hour. Vehicle took an exit and then began speeding at 114 in a 50-mile-an-hour zone. Traffic stop was conducted. Driver was identified as the defendant. Defendant had a suspended license. Officers detected a strong odor of alcoholic beverage, thick-tongued speech, droopy and glossy eyes, and the defendant to be unsteady on his feet. SFSTs were conducted 6 out of 6 HGN, 4 out of 8 walk and turn, and 1 out of 4 one-leg stand. DIC was red. Defendant refused to provide a sample. Blood search warrant was executed and blood was drawn.
Tell me why it was suspended. Are there any prior DWIs?
Nope. No priors, Judge. Let me see what the action was for suspension.
Mr. Perez, I'm going to find that there's probable cause to go forward with your case. You speak English, correct?
Yeah.
I'm telling you now, that if you drive, I will have a hearing as to whether I'm going to hold you in contempt, and I can slap you with 180 days in jail every time you drive. You will be signing a promise. This is an affidavit that you're going to promise to me today that you're not going to drive. I don't give a rat's ass what you have to do in this life. Do not drive. Do you understand? You were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication, and you will be tested crazily to ensure that you're not using. You do. Likewise, into jail you go. This is not a revolving door. You pick up another case, you violate any condition, you endanger my community, I'm just going to put you in jail, make your bond high. You understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
We will give you time. I'm going to have you come up here, swear to us you're not going to drive. I'll have you sign a reset. You'll eventually meet with Veronica for your bond conditions, then we'll give you time.
Thank you, Your Honor.
All right, Judge, next is bottom of 18, Rogers.
114. Good morning, Mr. Rogers. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 9th in Harris County, officer dispatched to a home invasion call at an apartment complex. The complaining witness stated that he was in his garage with a witness and family when the defendant approached asking for a phone charger. They stated he was going to keep the phone charger. The complainant told the defendant he could not keep it. The defendant then attempted to run into the complainant's residence. The complainant told the defendant to leave multiple times. The defendant refused. The defendant became aggressive and attempted to fight other people at the residence. The defendant attempted to then get inside the complainant's vehicle. The complainant continued to tell the defendant to leave. The defendant refused. The complainant stated that he does not know the defendant.
That's You're very lucky you're not charged with a very serious felony case, Mr. Rogers. As a condition of your bond, you were ordered not to go back to this location. You were ordered not to consume alcohol or illegal drugs, and I'm going to test you within the next couple days to make sure that you're not using. If you do, I will put you in jail. I don't know who you have in this life, but if I make your bond $20,000 to $30,000 and you don't have anyone to pony up that kind of money, you will be sucked like Chuck in our jail for who knows how damn long. It will take, and it usually takes about 9 months just to get a 911 call. You will sit in custody for a long time. Do you understand? You will get a monitor on your ankle and you're not to go into the 1,000 feet of where this person lives or works. No weapons. Like I said, any violations, in you go at a high bond. You know, I think it's probably prudent to put what time of day or night was this? Was this in the middle of the night?
11 p.m.
You have quite a bit of history in the last couple years. This happens at midnight. It's probably time for you to stop going out in the middle of the night, and you will now get a curfew. 9 p.m. to 6 a.m., you must be indoors. You violate that curfew, you know what's going to happen. Do you understand, Mr. Rogers? Do you need a court-appointed lawyer? Let me see if I have one on file already. I need you to fill out an application for me. Deputy Etchegon will give you an application. I'm going to have you meet, sign a reset. You'll get with Veronica for your bond conditions. Then we'll have you take your seat in the jury box.
All right, so top of 19, Ryan.
Mr. Ryan, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 6, 2026 in Harris County, officer dispatched an assault call at the Vanderbilt apartment complex. The complainant is a resident of the complex and stated that she's the defendant's ex-girlfriend and was in a dating relationship for 4 years before ending it a month ago. The complainant stated she was arguing with the defendant about him urinating on the complainant's front door. The complainant then advised the defendant she was going to call law enforcement and assisting in his removal of him from the residence. The complainant stated the defendant then lunged at her, dragging her into the residence and started punching her in the head and face with a closed fist an unknown number of times. The complainant stated because of the assault, she had bruising in her face and a busted lip and felt pain from her injuries.
There are 3 other assault of family members with Mr. Ryan that are priors. Are any of these the same complaining witness?
They all are, Judge.
They all are. A 4th assault of a family member, all the same complaining witness. Mr. Ryan, look at me. I'm going to put a monitor on your ankle. If you go within 2,000 feet of where this person lives, works, breathes, I will deem you a public danger. I'm going to throw your butt in jail, and I'm going to make your bond with many zeros by the end of it. Do you understand? Do not have contact with this person. Don't go anywhere near where they live, work, breathe. Do you understand?
But it's not true.
Stop. That's why we have trials, and we will have a trial. But what I'm trying to do is prevent any further calamities. And the way that we do that are with bond conditions, keeping everyone away from everyone. Do you understand?
Yes, sir. We're dragging my bike all the time already.
This is not an argument. This is not a negotiation. You have picked up another assault of a family member. I'm telling you what the deal is. There are bond conditions. You either live to the conditions or you die with the conditions. I'm not asking much. All I want you to do is stay away from this person and don't have any weapons. I put a monitor to ensure that it don't happen or you don't go near. I'm not asking much. There is a protective order that has been issued in this case, and you need to get to know it. If you violate this protective order, the state can and probably will file a violation of protective order, and that is the capital murder of misdemeanors. Don't violate the protective order. That means don't go where they live, don't have any weapons, don't have any contact, don't use third parties to attempt contact. Do you have the ability to hire a lawyer? We will give you time. I'm going to have you go to Vikky first, sign a receipt. I will have you take a seat in the jury box. You will meet with Veronica for your bond conditions, and after that, you'll be free to go.
All right, Judge, top of 21, Samoy.
You say Savoy?
Savoy, S-A-M. O-Y-E. S-O.
There we go. All right. Good morning, sir. So you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On May 7th in Harris County, officer observed a vehicle without a rear license plate and conducted a traffic stop. Defendant was identified as the driver. Officer ran the defendant's driver license, which was found to be suspended.
Mr. Samoy, you're not allowed to drive. I don't care what you have to do in this life. You will be signing an affidavit with me today promising me you're not going to drive. If you do, I can have a contempt hearing every time you drive. You could be facing 180 days in jail and a $500 fine and a contempt charge. Do you understand? Just no. Don't drive. If you want to drive, go get a license, get insurance. If you come back to me and show me that you have it, I will happily take this restriction off. But until that point, do not drive. If you do not have car insurance and you get into an accident, someone else is going to be out of a lot of property and money, and that's not fair. Do you understand? This is why we do what we do, not to harm, hurt, to belittle. It's because it's fair for the other person. Do not drive. You have the ability to hire a lawyer.
No,
How do you support yourself?
work. I work in a restaurant. It's written restaurant.
Deputy Etchigon will give you an application. I need to know whether you qualify for an appointed lawyer. We just don't give them out like it's candy. You have to qualify, meaning that you are on the poverty level according to the federal guidelines. So what I'm going to have you do is Deputy Etchigon will have you sign an application for an appointed lawyer. I'm going to have you come up here, swear test that you're not going to drive. I'm going to have you go to Victoria Sign and Reset, and then we'll have you take a seat in the jury box. Please.
Okay.
All right, Judge, bottom of 13, Luther.
Howdy, Tyler.
Morning, Judge.
Happy Friday, man.
Happy Friday.
You ready?
Like,
What's the thing? What's his last name?
Luther.
Come on up, Mr. Luther. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On May 9th in Harris County, officer observed a vehicle near the intersection of Milam and Preston travel northbound in a southbound one-way lane. Officer stopped the vehicle and observed the defendant in the driver's seat. Defendant stated he was coming from a bar where he had consumed alcohol, specifically 2 gin and tonics and 2 Modelo's. Officer detected a mild odor of alcoholic beverage, slurred speech, and glossy eyes. SFSTs were conducted 6 out of 6 HGN, 4 out of 8 walking turn, 3 out of 4 117. The IC was read. Defendant provided a breath sample. Results were 0.07 and 0.072
You said that he was driving the wrong way
on a one-way.
on a
street.
one-way. Okay.
may I, your attention?
Sure.
My client, works for Exxon. He lives in Baton Rouge. He was in town for training and was meeting some of the other people downtown. Wasn't familiar with downtown. We're not disputing the one-way street, but I do have a couple issues. One is the way that it reads is that the officer saw him driving down the one-way street and then pulled him over and then he pulled him out of the car. And then he didn't smell any odor of alcohol, or he didn't even, on the DIMS, he didn't state any signs of intoxication.
But he's allowed to pull someone out of the car. I mean, an officer anytime has the authority to pull him out for whatever reason, you know?
Then he was under the limit.
I get it, but that's not dispositive of in and of itself. I mean,
It's not-
when he pulls it, he smells the odor. What? tell me
Mild
what-
odor of alcohol, slurred speech, and glossy eyes.
So it's after, so the traffic stop is a 1/4 Amendment seizure, and then pulling him out of the car is a separate 4th Amendment seizure. I think you need to have some reasonable suspicion for to pull him out for an investigating either guy, but you just pull him out as soon as it's done. When outside the scope, in my opinion, they're allowed to do.
And maybe for beyond a reasonable doubt, but for purposes of PC, it's a very low burden. And an officer is allowed to pull someone out.
Yeah.
Here, he pulls him out, he sees slurred speech, or he hears slurred speech, there's an odor of alcohol, and I think that there's enough to go forward, sir. Beyond a reasonable doubt is a different standard in and of itself, but for purposes of probable cause, I'm going to find that there's probable cause to go forward, Mr. Luther. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You are not allowed to drive unless you have a valid Texas driver license and liability insurance. You say he's out of town?
He lives in Baton Rouge.
Okay, as long as you have a valid license, including a Louisiana license, great. But you also need liability insurance. If you don't have car insurance in your name, do not drive. And just don't use alcohol, don't use illegal drugs. You're going to get tested. Don't drive unless you have those 2 documents and then you're fine.
And just, he's being tested by Exxon. They're extremely strict. My wife worked there for 7 years.
I get it, but I don't know. If he gets called upon, he'll have to go to a Quest diagnostic if he's over there, because I know that Quest is legitimate. You're not allowed to go to Ponca City, buy a test. It has to be a Quest, so we know that it's legitimate. Get it to him. It's your responsibility. Usually when we call someone to test or to come downtown, they go to pretrial services and then we pay for the test so it doesn't come out of your pocket. But here, I can't pay for it. So you'll be expected to go to the Quest, get the test done, get it to Tyler, he'll get it to us, and then everybody's happy. Do you understand? All right, we'll have you sign a reset. You'll,
Ponca City, is that a real place?
well, That's what my dad used to tell me, so I don't.
All right, thank you.
Bye, Tyler. Happy Friday, please.
Judge, bottom of 7, Flores.
Dang, another reckless driving. Hey, can you spit the gum out? I'm chewing like he's a small farm animal. Mr. Flores, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
On May 9th in Harris County, officer conducted the traffic stop on a motor vehicle after observing it do donuts in a parking lot of a Family Dollar store. Plainclothes officer at that meetup in the parking lot observed the motor vehicle in a pit doing donuts, getting within 5 to 10 feet of striking others and vehicles. The traffic stop was conducted and the driver defendant was identified by Honduran and passport.
Sir, I'm going to find that there's enough probable cause to go forward with your case. You do not have a Texas driver's license. You are not allowed to drive. I don't care what you have to do in this life. You will be signing an affidavit with me today promising me that you're not going to drive. If you do, I will put you in jail. I don't care what your excuse is. I don't know what your immigration status is, but if you're not in this country with permission, and you go to jail and immigration finds you, they may very well put a detainer on you and you will be in custody for a long time. Do you understand?
Yes, sir.
I'm going to have you come up here. You're going to promise to me and sign an affidavit that you swear you're not going to drive. Do not drive. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them and they'll tell you if and when you have to come back to court. If they tell me they cannot get a hold of you, then likewise, I will revoke your bond. So for now, we will have you come up, swear to us that you're not going to drive. I'll have you sign a reset and then we'll have you take a seat while we get your bond conditions. Thank you.
Bottom of 21, Stewart.
Good morning, Ms. Stewart. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On May 8th in Harris County, officer spoke with the complaining witness who observed the defendant enter the Walmart and began placing trading cards into a shopping cart. Defendant then walked to the auto department and transferred the trading cards into her purse. Officer detained her after passing all points of sale without making any attempt to pay for the items. Defendant admitted to consigning the cards in her purse for a total of $511.47.
Ms. Stewart, I'm going to find that there's probable cause to go forward with your case. As a condition, you're not allowed to go to any Walmart for any reason. You understand?
Yes, sir.
If I find that you do, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. This is not a revolving door. Do you have the ability to hire a lawyer?
I'm not sure yet, like right now, like I'm on like a stable job, like I have like.
Are you working at this time?
I do kind of like a side gig type of thing, so I guess not like consistent income, so, you know, I'm trying to bring things around, if I could. I guess, file the form to see if I qualify for.
Sure. Deputy Williams will give you an application. I need to know everything, whether you're married, other income that you have coming in, boyfriend, whatever it may be, just all it's household income. So whoever you live with, all that income needs to be reported, and then I'll take a look to see whether you qualify.
Okay.
Deputy Williams will give you the application. I'm going to have you sign a reset. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions, man.
Okay.
All right.
Thank you.
All right, Judge, next is top of 22, Taylor.
Ms. Taylor, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 3rd, in Harris County, complaining witness stated the defendant arrived at the residence and damaged both side mirrors of his vehicle. Complainant personally observed and immediately recognized the defendant as the individual responsible for the damage. Defendant used a Yeti-style cup to strike and break both side mirrors. Cost to replace it is $400 each, totaling $800. Complainant stated the defendant has a pattern of conduct, including driving by his residence, waiting outside, and previously entering his vehicle without permission.
What conditions should we place other than obvious no contact? Anything else you think? Ms. Taylor, I'm going to find that there's probable cause to go forward with your case. There are a multitude of ways that we can ensure that you don't go near this person, including a GPS monitor that is huge, clunky, and extremely embarrassing to put on your ankle. I'm ordering you not to go near this person's house, not to go what street they live on, where they work. You violate this. First, I'm going to put you in jail, and then I'm going to put that monitor on your ankle. I will give you the benefit of the doubt now, but when I mean no contact, I mean no contact of any kind. Social media, phone calls, text messages, use of third parties, going near where they live, where they work, nothing. Do you understand? It's a yes or no.
Yeah, no, I do,
Okay.
I do. I just, can I ask you a question?
You need a lawyer. Unfortunately, everything you say here, they're sitting it down. They're going to sit there. They're going to type to prove your guilt. So what it just, these are the normal course of things. Whenever you pick up a criminal case and there's an alleged complaining witness, the idea is to keep everybody away at all times so that nothing should further happen in the future. Do you have the ability to hire a lawyer?
Yes,
We will give you time. I'm going to have you go to Victoria, sign a reset. We'll have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Would you please do me a favor and let the complaining witness know of what we have ordered
Yes, sir.
so that in the event that she tries, we can.
Yes.
Thanks.
All right, Judge, next is page 23, Williams.
Is Kara Williams?
Yes, Judge. Both cases are new. One just got put on for the 18th instead of today.
You're on bond for criminal mischief. You pick up an assault, and now you've picked up a robbery. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On the assault, Judge? Or on the criminal?
Both,
Okay.
all three.
Okay. Starting with the criminal mischief charge, Judge. Complaining witness is the ex-boyfriend. On August 8th, 2025, officers dispatched to a home in Harris County, spoke with the complaining witness who advised that he was at his friend's house when the defendant came over, got angry with him being there, and then walked outside and slashed two of his tires for a value of $700. The witness on scene confirmed the complainant's story.
Okay.
The assault charge, Judge. Same complaining witness. On September 27th, officers dispatched to a residence and met with the complainant and the witness. Complainant advised that the defendant, his ex-girlfriend, had come by the residence earlier and began causing problems. That she was upset because she has a pending case against her and believes it was because he called the cops on her previously. The argument escalated to be physical when she punched him in the face and then pushed him over a table, causing him to fall. While he was on the ground, she got on top of him and grabbed him by his hair and struck him multiple times with her other hand. Complainant advised he felt pain.
Okay. Robbery, please.
This one's the robbery charge. Statements that it's in the 179.
Tell me, do we have a trifecta, the same complaining witness on the robbery as well?
No, Judge, different person on the robbery. May 8th, 2026, officer dispatched to a food mart in Harris County for a robbery call. Officer met with the complainant and observed the defendant to be on the scene. Defendant matched description, fled on foot, but was detained at the front of the store when she saw the officers. Defendant Williams was detained in front of the store. She was Mirandized and gave her statement that she helped a co-defendant kick the complaining witness out of the store because he asked her to. Complaining witness said that after a verbal altercation, the co-defendant and the defendant They threw complainant out of the store into the ground, kicked her and punched her, causing pain and fear for her life. Complainant said the third unidentified male reached in his back pocket, patted the complainant witness down. Co-defendant took the complainant witness's phone from her hand during the attack, and the unidentified co-defendant told the complaining witness to give him $100 and password to the phone, or to give the phone back to her. Officers recovered the phone on scene, hidden in the food store.
Ms. Williams, this is not a revolving door. At some point, there are just no more PR bonds available for you. They gave you a PR bond on the criminal mischief. I'm not. No. You are a danger to, I can't give you another PR bond. It's just not going to happen. I'm going to revoke it. She's going to go with you. As a condition of your bond, you will wear a GPS monitor. You are not to have any contact with the complaining witness in this case at all. No weapons, and you will have a monitor on your ankle. So I know that you're not having contact. You're not to go within 1,000 feet of where this person lives or works. Do you understand? Do you see a protective order that's been issued in the, I'm entering now what's called a mattress order for emergency protection that identifies Mr. Williams as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harass behavior. You cannot go within 1,000 feet of where this person lives or works. Do you understand? You violate this, they may very well file yet a fourth case on you, a violation of protective order, and it just only gets worse. No contact means no contact. Do you understand? Okay. We're gonna, hey, and then Deputy Williams also for the MOA. Yeah.
That's it for now.
Wonderful. Hey, you ready? Come on. Hi, Mr. Bonds.
Hey, I had a vague, Mr. Herrera, we're gonna do a plea. He submitted a paper. He didn't complete pretrial intervention.
They kick him out.
Yeah.
Okay, are you ready?
Huh?
Are you ready?
Yeah, and I, you know, as far as the court's concerned, he's been jail because you were.
Yeah, I'm usually on the first. I'm okay with back time.
Oh, then, okay.
Yeah,
Mr.
well, we need him to come thumbprint. James, he's signed everything?
Yes.
Okay, great. We just need him to do a thumbprint and then.
Yes.
So, Mr. Herrera, you're charged with driving while intoxicated. You know, you may not today, may not be tomorrow, maybe not next year, but at some point you're going to kick yourself because you had the opportunity to have this DWI dismissed. And now, because of your failure to complete the intervention program, it will now go on your record. It will be there for the rest of your life. You will now forevermore be facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement and once you plead guilty, it goes on your record. You'll never be able to take it off. You understand?
Yes, sir.
How do you plead to this offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I'm now going to suspend your license for 180 days. Do not drive until you get a license. And good luck to you, sir.
Thank you.
And then we'll waive the fee.
Okay, thank you.
Hey,
I'm not on that. We don't, that was the case from.
Sure.
So, I spoke with Ron. It looks like for whatever reason, she talked several months.
Take it downstairs.
oh, is it-
For,
really?
this, yeah, I think it's talking about, one of them actually told me they want to make, they just want to make money, so they can do one with it.
They want to make money, so they don't want to work with her?
Because they wouldn't make money. Okay.
Well, I mean, they're in business, right?
You know,
But how much,
So the bond we set was at 500.
Sure.
When we set the bond, we assumed that she would pay, the 10-20% or whatever it is. Everyone which is up to now has said that she's just gonna have to do, the 100%. So if we're banking on her getting
I'm not giving her a $50 bond.
$100 bond, because she's gonna have to pay the full amount. And I'm happy to get her on the phone, so.
What do you think?
That's her.
Can I get 100% of the
Oh.
time?
So I figure if that's the amount of money she was gonna put up anyway.
Hey, Martin, I see you. I saw Miss Green here. Yeah, we'll do it.
We're ready to go on that.
Yeah, we'll do it next.
I don't get on phones or.
Well, I gotta get, what are they? What are they?
Stay with you. I was just gonna second offense.
Well, it's really a third. But so what's reasonable though? The reason is they offered her
Yes.
the program.
She's not even gonna get out today. She's gonna get out on Monday. She's got the monitor. There's no way they're gonna process her out.
What's a reasonable amount? What do you think? Because of all the flight that she has, and you need to advise her this, like because of all the times that you have forfeited.
We've spoken to her extensively.
Oh, okay.
State, we'd be fine coming down to 250, splitting it.
All right. So you want 100, he wants 250. Let's split the baby. 150.
Okay.
Yeah.
Thanks, Josh.
Do you, can I have the cause number,
Yes,
please?
Judge, it's 258, 2517.
Did you see one? Did you get it? 258, 2517. We're going to do a further bond reduction to
I will let her know.
150. But that's it, man. Sebastian, that's, all right. Are you ready? Ms. Green, come on up. So they're dismissing the assault.
Yes, sir.
Ms. Green, you have worked out an amazing deal. They're going to dismiss the assault in exchange for your plea on the failure to ID. Not many times in life that you're going to get such, you understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, it will stay like this forever. Now, you need to understand this is a Class A misdemeanor. So if you pick up another one, you will be looking at a minimum of 90 days in jail. Do you understand?
Yes.
How do you plead to the offense, man? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will follow the agreement, sentence you to it. And good luck to you.
Thank you, Your Honor. Maybe.
Thanks. You got it. Thanks, Martin.
Are we?
You too?
Step over here.
Kobe, ready?
Yeah.
Hey, bud.
Morning.
Good morning.
Mr. Demetria Murphy, I'd like you here, bond violation.
Again.
So it's from the drug test that you said before, last time we were here. Good news, said no problems on her scram, no alcohol.
She's still testing positive, though.
I understand. It was, it's like it was for hydrocodone, a couple of pain pills, just let you know.
Does she have a prescription? Miss Murphy, come up.
Now that I know.
Regional Services does not receive.
Okay, well, hold on, Miss Murphy. Or come on up.
We'll tell you, Judge, she did
Take a seat.
test today, drug test today, it was negative.
I understand that, but that's not the problem. It can't continue. At some point, we have to say when. It's a violation after violation. And the problem is that if I let you go now, I'm telling you, it's okay for you to continue to have bond violations. And it's not. At some point, we have to say enough is enough. Do you understand?
Yes.
Okay. Sorry. Look in your bond.
So you know, the first bond violation was just from sick death, but this is the first substance. So I understand, but
When my child keeps telling me, I'm sorry, Dad, I'm sorry, Dad, I'm sorry, Dad. The sorries at some point have no value. Do you understand? Okay. Let's talk about a bond.
sorry.
Let's talk about a bond. What do you think? What's reasonable in light? What do you want? Reasonable.
You're into 2,500.
We'll split 1,501. All right. But tell her it's no tolerance. Further on? Yeah. Okay, my friend. Good morning, Mr. Guerrero.
Good morning.
So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 25 days in jail with the credit that you received. I think it's what?
7 days.
Really? Wow.
9 days credit, Judge.
That's even more of a wow. You were giving up a lot of rights by entering into this agreement, Mr. Guerrero. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you plead guilty, this will go on your records. You can never take it off. Is this what you want to do?
Yes, sir.
You need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases, at least 30 days. All right? All right, sir, I'm going to find you guilty. I'll follow it. Good luck to you, sir. Thanks.
Thank you.
Mr. Brown. You got it. Have a wonderful weekend.
You too. Thanks.
Mr. Bernardi. Again, another BBR.
We worked out a plea with the state, Your Honor.
Tell me.
It's a time served.
Oh. Okay. Mr. Riley, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have worked out is 2 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It will be there forever. You understand? You're now on, will be facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So this is final today. You can never change this. Is this what you want to do?
Yes.
How do you plead to the offense? Guilty or not guilty?
Yes.
I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir. Thank you, Mr. Bernard. Good morning, Kavita.
Morning, Judge. Took me a minute to find my unmute
Hi.
button. How are you?
Happy Friday.
Happy Friday. I just have one with you in the holdover. Danny James.
Yes, ma'am.
Mr. James, we have a plea agreement in felony court to do probation. So I can iron out the details to see if felony will dismiss the misdemeanor once he pleads on the or
You want to
if-
set it for after the felony?
That'll work, Judge. I think he has a TRAS on June 10th. Judge Jones won't do a plea until after the TRAS, so I think we're June 15th. So June 16th would be fine.
Yeah, okay. Done.
Okay. Thank
Okay,
you.
have a great Friday.
You too, Judge.
Bye.
Bye.
Miss Stewart, come up. I mean, really. You were just now telling me that you work, that you do have some income, and yet you put zeros in everything. Stop. I will send you home with an application, and I want you to be truthful. When you come back, I want you to do everything that you can, be honest on this application. This is a sworn document that is perjurous if you lie and can be a potential felony offense. Do you understand? It's not a joke. Please. She signed her, make sure she signs her bond conditions. Good morning, Mr. Gerard.
Good morning, Mr. Fleischer. You look nice this morning.
Thank you. I appreciate that. Give me 1 second. All right, so Mr. Gerard, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done. You need to understand that this will now reflect as a conviction on your record. I don't know how many thefts you have, but if you continue to pick it up, at some point they may hit you with a felony. A third theft is a felony offense and you're looking at years instead of days. You understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So this is final today. You can never change this.
Yes.
Is this what you want to do?
Yes.
How do you plead to the theft? Guilty or not guilty?
Yes.
I'm going to find you guilty, and it looks like the other case is going to be dismissed, right? All right.
Thanks.
All right. Good luck, Mr. Gerard. Take care, miss.
You keep on the great work.
Filing it dismissal now.
Thank you so much. Do you want to go through the list so far? Hey, be efficient, dude.
Me? You tell me that. I'm efficient.
My name is Bennett, and I ain't in it. Oh, Greg. I saw Greg. What happened? The dude no showed again? Oh, they dismissed? Okay. On that no PC case,
Yes, Judge, the DWI?
yeah, you reset it. Did you can dismiss? Reset it? Okay. No, yeah.
Okay.
No, no. Bottom of page 5, I guess, huh?
Yes, Judge. And top of the stairs.
2501 on DeLorean. Oh, yeah, got it. Yeah.
Top of 5 is supposed to approach. T-Rest is 5. I don't want to.
Oh, Darla's here. Darla.
Oh, okay. Top of 5.
Yes,
Darla,
Judge. Yes,
I'm
Judge.
sorry, I totally forgot about you. Next time, just yell so I don't forget, you know?
That's fine. I was just listening.
Wait. Oh, hell no. The case is 207 days old. You reset it for a month? No.
No. Judge, you reset it for us to get a TRAS. I submitted the request. That's the date we got.
Yeah, but sooner than a month. You're 200 days. So I don't,
I'm
pick a day
agreeing.
next week. I don't care, whatever you want.
So I just tell my client, pick a day that we can come in and
Well,
determine.
let us know so we can reset it for that day. Have him come in and we'll send him for a walkthrough TRAS and then we'll give you another couple weeks to finish everything up. But I don't want to, you're 207 days. We're going to set it for another month.
Yeah, I
a month and a
didn't
half.
pick that TRAS date, so I'm perfectly fine with that, Judge.
Yeah, whatever you want. I don't care.
Okay, you want me to give it to you now?
Sure.
Okay.
A way to be
The
efficient.
21st, May 21st.
Okay, so just let him
Perfect.
know to be, or him or her.
It's a guy.
Yeah, so let him know to be here. The earlier he gets here, the sooner we can send him for the TRAS. If he gets here first thing in the morning, we'll send him first thing in the morning. The sooner he gets here, the sooner he'll get through. So there's no line of other people, you know?
Sounds good.
And then after that, just pop in again and we'll give you another 2 to 3 weeks to finish everything up after that.
Perfect.
Okay?
Thank you.
Okay, have fun.
You too.
Page 10, bottom of 10, top of 11.
No show?
Correct.
25, 5,002 on both. And then I got to do a bail order. Did you guys dismiss Owen? It's a PTI. Looks like, is it ready to be dismissed? Yeah,
Yeah, all right, I thought.
you did? Okay.
Judge, how much did you revoke bottom of 14 for?
1501. And then they're going to dismiss Owen, top of 16, top of page 17, 2501, top of page 20, 2501. I'm assuming right underneath it, same thing. 2501. What? Oh, I guess Val's client never came, huh?
That's the business?
No,
Oh, no, yeah, that was.
If we never, okay. 5,002 on. What you talk about, Willis?
Good morning, Judge.
Hey, come on up. Good morning.
Okay, so I am here, on a Ms. Williams, who's, I guess, we should take it in.
Yep.
So I'm trying to understand, Judge, what's, why?
She's picked up 3 successive cases. At some point, we can't continue to give her,
Well, but I think the issue here is, Judge, the 2 misdemeanors that, they were 2B, so she was never taken in. She was taken in on the misdemeanor on the day that she was arrested for the felony. So everything happened on the same day. So it wasn't like she had a PR bond, she was out. She never had a PR bond. She was going to give her a PR bond the day after she picked up the robbery because she had over 2 meetings.
but they didn't all happen on the same day.
They did. No.
They did not.
No, the misdemeanors were 2 weeks, so they have.
I get it, right,
So.
right, but
But she never had a PR bond. There was warrants,
I understand.
which she was unaware of.
But I think that she's a danger to the community. Has 3 to 4 different victims. She picked up 3 cases, one of them being a serious robbery. And I don't know if it's a good idea to just,
Well, I guess the issue is she actually posted bonds. At least a bond.
I'm not touching her surety bond. I'm not touching anything else. I'm just not gonna, and I'm leaving the bond at $100. I'm just not gonna give her a PR bond.
Oh, okay.
I just don't think it's a good idea what conditions can we place that will protect the community?
Well, I think because she actually posted bond in the felony case, then we could mirror the bond, the felony bond. And because she actually posted a bond for that.
The only condition that they really put on there is don't go back to the food mart. She's charged with a robbery. The only condition other than no firearms is just don't go back to this place. It's a robbery case. And the only thing they did was put no going back.
Well, so then.
And she has a mischief, an assault, 2 of the same complaining witnesses, and now a robbery. Clearly, she's a danger to the community. What can we do to protect the community?
Well, we could definitely put a condition, obviously, that's the only condition for the felony. And obviously, the first condition would be obviously no communication with the complaining witnesses, which I don't know why that was not a part of the felony bond. So we could definitely have no communication with the complaining witness, for those, yeah.
I don't want her to get the appearance that this is a revolving door. That's what I don't want. I don't want her to think, hey, I could just continue to pick up 3 cases and I'm just going to walk out of jail. Just no problems, no conditions, just don't do anything. And that's what it seems like, and at what point?
Well, I guess, I understand at what point, but I guess my point is, this is like the starting point, because she never was, because she had a 2B, so she never actually got an opportunity to come to court and show the court that she would be able to comply. These cases probably would have been over if she had got picked up at some point in time, but because they were 2Bs, this is like the starting point. So I think at what point will probably come later. This is like the starting point. She just got arrested on all these cases on the same day.
What do you think?
I'd be opposed just because of the facts of the AFM. She acknowledges that she has a pending case open, and that's why she goes and assaults the complaining witness in that case. So I think that she knew, to your point, about the case that was pending and then still committed allegedly the second offense of a.
Tell me that, because I didn't know about that.
So she was upset because she had a pending case against her and believes it's because he, the complaining witness, called.
I'm not giving her a PR bond. It's not going to happen. She knew, it's just not going to happen.
That's the assault family member.
Okay. Well,
I'll leave the bond as is at $100.
I think there's something that he's giving me a false perception of. What he's referring to is the case is the old case, the previous case that she had 2 Bs on, not the robbery case.
I know. I'm talking to referring to the criminal mischief. Yes, I understand.
No, I guess my point is, he was trying to give the perception that she knew about the warrants, so that's when she committed the robbery.
No.
Okay, so
The assault.
the assault.
She has an open warrant for a criminal mischief on this person where the alleged tires are slashed. Goes up to him, knows that the mischief is open, and as a result, allegedly beats the living.
I understand. No, I understand. I understand. I was.
Let her know, please. It's not a revolving door. And I have also, we're not out for blood. Otherwise, I'd set her bond at $10,000, $20,000. I'm leaving it $100, but I want her to understand it's not a revolving door. You know what's going on, yet, number one, you evade. Number two, you pick up an assault, and then now a freaking robbery. Really?
Understood.
Yeah. Okay, I'll leave it as is. So, hey, I have put GPS prior to release, no contact, no weapons, no drugs, no alcohol, and then so she doesn't have any contact with this person, please.
Yeah. I let her know, Judge.
Okay,
Thanks, sir.
thanks.
Yes, sir.
You ready? Yes.
Have Crockett and Docket in the jury box.
Come up, Mr. Crawford
Crockett.
or Crockett, bring your stuff.
Your Honor, his wife is in the audience as well.
We'll do probable cause first. I'm not going to do anything until we do probable cause. Mr. Crockett, where did you think you're coming? To the beach? Huh? Is this an appropriate way to dress? You're going to a criminal court. You're not going to the beach. You're not going to hang out with your friends. This is not about, you're coming to court. You're now stand charged with another case. You're charged with assault. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On May 9th in Harris County, officer dispatched to a Family Dollar store regarding a disturbance call. Officer observed a complaining witness lying on the ground, bleeding from the mouth. A witness, a coworker, showed video footage of a male who witness advised assaulted the complaining witness. Officer reviewed the video, which showed the complaining witness standing at the door, the defendant to get in his face, complainant push him away, and then defendant striking the complainant twice, causing him to fall to the ground. A citizen advised the officer that the defendant was walking northbound to the store. Officer observed the defendant matching the description of the male in the store video. Defendant was detained. Complainant advised that the defendant struck him with a closed fist on the right and left sides of his face, causing him to fall and lose consciousness.
Wow. Lost consciousness.
Yes, Judge. Complaining witness advised that he believes his arm was broken and he was in extreme pain.
Is there a broken arm? I think you need to follow up. That's some serious injury.
Yes, Judge.
Mr. Crockett, I'm going to find that there's probable cause to go forward with your case. The only thing I told you not to do was pick up a new case. The tears that you shed now are probably the same. I am now revoking your bond.
Before you revoke his bond, and I'd like to address what he's wearing in court today. He is homeless and these are the only clothes that he owns. If you have other clothes, he would dress more appropriately. And he's crying because he's worried about his kids and his wife who's here and who's gonna protect them when he's not there. His wife was here at this incident at the dollar store when, as it says later on in the DIMS, before the state finished reading, that Mr. Crockett said so himself that he was pushed first and he was harassed by the employee and was defending his wife.
You said there's video on this?
That's what they didn't say, Your Honor, yes.
We will get the video. Mr. Crockett, you picked up a new case and the guy, or was it a guy or a girl?
I believe it was a male, Judge.
Lost consciousness. You always have the ability to go and walk away. No one forces you to do anything in this life. You can walk away. You're the one that's on bond, and I advise you when you get here, I'm going to protect my community at all costs. And if I have to throw your ass in there because you were a danger to it, then that's what I'm going to do. But it's unacceptable that you are on bond and you picked up a new case. If you have kids, if you have a wife, this is what you think about before you allegedly lose self-control. You will now go to jail. Goes with you. Perhaps now we will get your attention. The bond is set at $100 in the assault. I will leave that as is. But due to the violent nature, I'm going to now set your bond limit trespass at $5,001. If you do get out, you will get a monitor and you're not to go anywhere near this store or near the complaining witness or not to have in possession of any weapons. And let me tell you, if you do get out and you pick up a third case, I'm going to go bananas on all of your bonds. Do you understand? Thank you.
Judge, what's the new bond amount?
5,001.
And that's only on the criminal trespass?
Yes, ma'am. Hey, can I send them? Can they go?
Judge, yeah, they're not Spanish speakers.
Guys, we're done. Go. Have fun. Have a great weekend.